Did you know that when India became a republic in 1950, the Constitution didn't actually create a permanent comprehensive system for citizenship?
It's a really startling fact when you first encounter it.
It is. It did something much more specific. It only defined who was a citizen on that single chaotic day, January 26, 1950, and then it basically passed the torch.
Handed the whole thing over to Parliament.
Exactly. It gave full sweeping power to Parliament to manage everything after that. This part of the Constitution, part two, it's like this incredible time capsule, It captures the sheer complexity and I suppose the legal ambiguity of Indian identity right at its birth. And it set up these foundational ideas that, well, they still shape our political life today. Welcome to the deep dive, where we turn stacks of crucial study material like Chapter 7 of M. Laxmikanth's Definitive Indian Polity into crystal clear UPSC-focused insight. Now, before we unpack this incredibly foundational constitutional concept, we have a huge and a very humble request, especially if this deep dive really helps you with your preparation. Please subscribe to Simplify UPSC by PPP on YouTube. Your support, and especially joining our paid membership if you're able to, is exactly what lets us keep generating this kind of highly useful, detailed content.
It really is.
We also want to give a massive shout out and a huge thank you to all of our existing members. Your ongoing support is it's invaluable. It really keeps this mission going. And of course, don't forget to like this video and share your valuable comments down below.
So today, our mission is to meticulously summarize this constitutional framework of citizenship. We're focusing entirely on that founding moment, who qualified to be an Indian citizen at the commencement of the Constitution.
All right.
Specifically, we're looking at Articles 5 through 8, and then how that founding document set up a future legislative path through Article 11. Our sources are the core constitutional provisions themselves, and, of course, the synthesis provided by the authoritative 8th edition of M. Laxmikanth's Indian Polity. We're going deep here, providing that essential technical balance and historical context you need for serious UPSC preparation.
And just a quick but crucial note on resources. We know how vital practice and quick revision tools are, especially when you're dealing with specific dates and legal criteria like in this chapter.
Oh, absolutely.
So free notes that complement this deep dive, along with practice previous year questions. The PYQs are available right now on our Telegram channel. And for our premium subscribers, that is our Legend YouTube members, we offer premium notes, extra PYQs that focus on detailed analysis, and model mains answers exclusively on our Discord channel.
These are the resources designed to really push you from just understanding to actually applying the knowledge.
Exactly. So be sure to join those communities. Okay, let's unpack this core concept, starting with the scope. We're in part 2 of the Indian Constitution, which is Articles 5 through 11, all dealing with citizenship. But let's clarify the purpose right away.
Yes.
When the Constitution was being drafted, the framers were dealing with just unprecedented chaos after partition. They couldn't exactly wait for some comprehensive, decade-long legislative process to define the entire future identity of the nation.
They couldn't. The core function of Articles 5 to 10 was to provide a mechanism for transition. So important to get this right. They only determined who became a citizen of India on that specific commencement date, January 26, 1950.
So it's not a rule book for today.
Not directly. It's not an elaborate citizenship code in the modern sense. It's a one-time snapshot. It's a picture of the population that would form the republic at that exact moment. The founders very deliberately avoided writing in elaborate, static provisions for acquiring or losing citizenship after that date.
And why was that?
Well, because citizenship is inherently a dynamic, political, and sociological issue. They were wise enough to see that, so they deferred this complex, evolving legislative function entirely to the future parliament.
That makes so much sense. It's like setting up a new business, The Constitution defined the initial founding partners, that's the 1950 cohort, and then immediately gave the Board of Directors, which is Parliament, total ongoing control over who gets future shares and how they can be revoked.
That's a great analogy.
So the question then becomes, given the massive dislocation of partition, who exactly were these foundational partners?
The founders had to define that initial group using criteria that could accommodate 4 very specific and immediate categories of people. People who were all affected by the historical circumstances of 1950.
So they needed a different rule for each situation.
Precisely. They needed rules for the settled residents, rules for the incoming refugees, rules for returning migrants, and of course rules for the overseas diaspora. So the constitutional provisions dealt with citizenship for 1.
Persons domiciled in India.
Right, that's Article 5, the general rule. 2. Persons who migrated from Pakistan. That's Article 6 for the refugees.
Okay.
3, persons who migrated to Pakistan but later came back. A very tricky but generous provision in Article 7. And finally 4, persons of Indian origin residing outside India. Article 8 for the diaspora.
Let's start with that foundational pillar then, Category 1. Citizenship by domicile, which is defined in Article 5. Now, this article sets the general rule for anyone who was already on Indian soil and intended to make it their permanent home. But the core technical concept here is domicile. What exactly did the Constitution mean by that? How is it different from just, residence?
And this is a high-yield conceptual point for you, the learner. Domicile is much, much deeper than residence.
Mm-hmm.
Residence is just physical presence. It's where you happen to be living.
Where you sleep tonight.
Exactly. Domicile, on the other hand, is the legal concept. It signifies a person's permanent home, coupled with the intention to reside there indefinitely. It implies a legal tie, a real commitment to that jurisdiction.
So it's a state of mind as much as a physical state.
Absolutely. In the context of Article 5, the person must have had domicile in the territory of India at the commencement of the Constitution. So they had to show physical presence and that mental commitment to the new republic. It's the sine qua non, the absolute non-negotiable requirement of Article 5.
So just being in India on that day wasn't enough. You had to consciously choose India as your permanent legal base. Okay, so once that domicile was established, what were the 3 supplementary conditions required under Article 5?
Right. So in addition to proving this essential domicile, the person then had to satisfy one of 3 additional, more objective conditions. Just one.
Okay.
The first condition was the simplest. They were born in the territory of India. This is a nod to the principle of jus soli, the right of the soil, a simple birthright claim.
So domicile plus being born here, you're a citizen. Easy.
Easiest path.
And the second one shifts the focus a bit, moving from personal birth to ancestral ties, right?
Exactly. The second condition broadens the base using jus sanguinis, the right of blood or parentage. Either of their parents was born in the territory of India. This was designed to accommodate individuals who might have been born abroad, but whose immediate family roots were clearly within the newly defined territory of India.
So someone born overseas to Indian parents who were working abroad in 1950, for example.
A perfect example. This provision was crucial for stabilizing the identities of people who were geographically mobile, but still tied to the land genealogically.
And the third condition, this one's critical for those who might not meet the birth or parentage criteria, but who could show a long-standing commitment to the physical territory itself.
That's the temporal connection. They must have been ordinarily resident in the territory of India for not less than 5 years, immediately preceding the commencement of the Constitution. And that phrase, ordinarily resident, implies a continuous established residence.
Not just visiting.
Not at all. And for the prelims exam, you really need to remember the specific timeline. To meet this 5-year residency requirement on January 26, 1950, that continuous residence must have begun no later than January 26, 1945.
Got it. 5 years back from the date of commencement.
Right. This 5-year period was intended to weed out anyone who was merely a recent arrival or a temporary resident.
Yeah.
It was to ensure that the foundational group defined by Article 5 had a deeply established long-term connection to the territory and the future of the nation.
What's so fascinating about Article 5 is that hybrid nature. It's not pure jus soli, like in the U.S., nor is it pure jus sanguinis. The founders required this blend.
Yeah.
You needed a territorial connection, birth, parentage, or 5 years of residence, but that connection had to be fundamentally anchored by domicile,
Right.
the conscious intent to belong to India. Why did they go for this complexity? Why not just use birthright?
Well, that complexity reveals the core dilemma of 1950. Pure jus soli was problematic because millions of people were fleeing and the borders were still fluid.
Okay.
And pure jus sanguinis was too rigid, especially given the colonial context and the diaspora. So by insisting on domicile, the framers ensured that citizenship was ultimately a matter of choice and commitment, rather than just an accidental geographical fact. It provided a constitutional filter that allowed the settled, committed population to immediately assume their full rights and responsibilities. You could say Article 5 is the constitutional soul of that founding moment, defining the core residents who remained. So, having settled the resident population under Article 5, the Constitution then had to immediately deal with the massive humanitarian and legal crisis caused by partition. Articles 6 and 7 are purely transitional rules. They're about managing migration across that new border.
Let's turn to Article 6 then. This deals with Category 2, persons who migrated from Pakistan to India. This provision was critical, obviously, as it governed that huge influx of refugees. What was the absolute genealogical starting point for claiming citizenship under Article 6?
The overarching prerequisite for anyone claiming citizenship under Article 6 is that ancestral tie to the subcontinent. The person, or either of their parents or their grandparents, must have been born in undivided India.
So a pre-partition connection.
Yes. That rule linked citizenship to the historical territory before the split. If you lacked that ancestral tie, you simply could not use Article 6. But the real complexity, which is crucial for prelims prep, lies in the cutoff date that dictates the mechanism of acquisition. That date is July 19, 1948.
July 19, 1948. Why that specific date? I mean, it seems a bit arbitrary unless we look at the historical context. What changed on or around that day?
That date marks a massive political shift. You see, initially, after partition in 1947, migration was chaotic, it was free-flowing, immediate, but by mid-1948, the Indian government realized this needed structure.
Yeah.
The date of July 19, 1948 is significant because it was the day the permit system for migration between the two nations was officially imposed. Before this date, people could move relatively freely. After this date, migration became a regulated, government-controlled process.
Okay, that makes the two subcategories much clearer. So subcategory A would cover those who migrated before the permit system was imposed, before July 19, 1948.
Correct. And if a person migrated before this date, the process was automatic and quite generous, reflecting the chaos of the time. They were automatically deemed a citizen of India, provided they had been ordinarily resident in India since the date of their migration.
So just continuous resident after arrival was enough, no paperwork.
Continuous residence was the only condition. No formal application was required. The state essentially recognized the automatic citizenship of that early wave of refugees who had already settled down.
And subcategory B covers migration on or after July 19, 1948, the structured migration after the permit system began. How did their path to citizenship change?
For this later group, citizenship was not automatic. It required a formal engagement with a new government apparatus. Such a person had to be formally registered as a citizen by an officer appointed by the government of India.
And this registration requirement, it introduced a specific period of waiting, which I know is a common prelims question point, right?
Absolutely. Crucially, the source specifies a mandatory precondition for that registration. They had to have been resident in India for 6 months immediately preceding the date of their application. This is a vital difference from the 5-year residence requirement in Article 5.
Let's pause on that difference because it's important. Under Article 5, settled residents needed 5 years of residency to prove their connection. But under Article 6, and as we'll see, Article 7, migrants needed only 6 months before applying for registration. Why such a massive reduction from 5 years to 6 months for the migrant group?
It's a crucial distinction, and it reflects their purpose. The 5 years in Article 5 was a test of historical commitment to the territory before the Constitution even existed. The 6 months in Article 6 and 7, that was a mandatory cooling-off period, a test of current intent. The framers recognized the immense duress under which migrants were moving. So the 6 months was required to ensure that the migrants' choice to settle in India was serious and permanent before they were formally entered onto the citizenship register. It was a mandatory show of commitment, not a historical proof of connection.
That really contextualizes the rules beautifully. Okay, now we have to address Category 3, which is detailed in Article 7, the return migrants to Pakistan. This is often the most confusing scenario, people who left but then came back.
Yes, this provision deals with those who initially moved out of India to Pakistan after partition, only to, well, realize their mistake and subsequently return to India for resettlement. The Constitution had to accommodate the human drama of regret and failed choices made during such a chaotic period.
So what was the critical date that triggered the loss of citizenship by moving to Pakistan in the first place?
The critical starting date for the migration to Pakistan is set quite early, after March 1, 1947. If a person migrated to the territory that was now included in Pakistan after this date, they were generally deemed not to be citizens of India at commencement, based on their initial decision to leave.
So their status was initially nullified. How did the Constitution then provide a pathway for them to reacquire that status?
It provided a very specific second chance. They could become an Indian citizen, but only if they returned to India under a permit of resettlement or permanent return. The act of returning under this official permit signaled a renewed and formal commitment to India.
And the requirements for getting citizenship after returning?
They were identical to the later group under Article 6.
Yeah.
They must have been a resident in India for 6 months. immediately preceding the date of their application for registration.
That seems surprisingly generous, really, given the political turmoil of the time. Was there any debate among the founders about this? I mean, granting citizenship to those who had already chosen Pakistan, might it dilute the commitment of the original citizens?
Oh, absolutely. The debate was intense. But the final outcome really reveals the Constitution's surprisingly humanitarian approach toward managing the fallout of partition. The framers acknowledged that people's first choices were often made under immense duress, pressure, and, a lot of misinformation.
Sure.
By mandating the formal 6-month residency and the application process, the state ensured a formal vetting and a waiting period. But by allowing the path at all, they prioritized the resettlement and security of people over a strict legal formalism based on those initial, often traumatic, choices. Finally, let's look at Category 4, detailed in Article 8, which covers persons of Indian origin residing outside India, the nascent diaspora. This provision was vital for overseas Indians who had historical ties but were not physically on Indian soil at the commencement.
So what were the criteria for this group who were essentially claiming identity based on ancestry rather than current residence in 1950?
The criteria were rooted strictly in lineage. A person, or any of whose parents or grandparents, must have been born in undivided India but was ordinarily residing outside India. These were people with very clear ancestral ties who just happened to be living abroad when the Republic was born.
And since they weren't physically in India, they couldn't apply for registration in the same way the migrants did. So what was the mechanism for them to operationalize their claim?
This required a unique administrative solution. They had to be registered as a citizen of India by the diplomatic or consular representative of India in the country of their residence.
So at the embassy or consulate?
Exactly. And the beauty of this provision is its flexibility. The registration could occur either before or after the commencement of the Constitution. This is a direct mechanism set up to ensure that their ancestral connection could be legally formalized immediately, recognizing their identity as foundational to the new republic, even if they lived far away.
So to synthesize Section 2, Articles 6, 7, and 8 were really like surgical strikes. They were designed to handle the human complexity of borders and migration between 1947 and 1950.
They were. They provided temporary, specific rules for specific historical groups, ensuring the identity of the new republic was stabilized at the moment of its birth.
Okay, so we've established who was a citizen at the starting line in 1950. Now we move to the future. And this is where the Constitution's silence speaks volumes, really, ushering in the legislative supremacy of Parliament. Once those 4 categories defined the initial population, the Constitution kind of stepped back from the day-to-day management of national identity.
And that delegation of authority is the constitutional genius of this entire section. The framers recognized that citizenship laws must be flexible enough to evolve with shifting geopolitical realities, new definitions of the diaspora, new security concerns.
Things they couldn't possibly predict.
Exactly. If the acquisition and loss rules were written into the core Constitution, they would require difficult constitutional amendments every single time the state needed to adapt.
Right.
Therefore, the Constitution essentially ended its detailed involvement with the definition of the citizen and handed over the subsequent responsibility for managing citizenship entirely to the legislative wing. This is formally enshrined in Article 11.
Let's focus on that explicit grant of power. What exactly does Article 11 say about Parliament's authority?
Article 11 explicitly states that Parliament shall have the authority to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship.
So it's a blank check, almost.
It's an open-ended, sweeping grant of legislative power. It means Parliament holds complete supremacy for all rules governing citizenship post-commencement. This authority isn't merely implied, it is expressly provided to the legislature.
So the rules in Articles 5 to 10 are temporary.
But the power granted in Article 11 is permanent.
And this sweeping grant of power is the bridge to modern Indian law. Parliament immediately took up this mandate and enacted the Citizenship Act, 1955. This act is the mechanism used to regulate how citizenship is acquired or lost after the commencement of the Constitution.
And this is so critical for the UPSC learner. You must know the difference between the foundational rules in Part 2 of the Constitution and the ongoing statutory rules in the 1955 Act, as amended. The 1955 Act lays down pathways for acquisition by birth, descent, registration, naturalization, and incorporation of territory.
Let's talk about a key detail that illustrates Parliament's use of Article 11. The path for Overseas Citizen of India, or OCI, cardholders, to eventually transition to full Indian citizenship. This has been modified over the years, which shows how the state's relationship with the diaspora evolves. What are the key numerical rules for an OCI cardholder to acquire citizenship under the 1955 Act?
The rule is precise, and it's often tested in exams. A person who is registered as an OCI cardholder for a period of 5 years
Okay, 5 years.
and who has been ordinarily resident in India for 12 months immediately before making an application is eligible for the grant of Indian citizenship.
So that's a compound requirement. Why mandate 5 years of OCI status plus 12 months of residency before the application? Why the waiting periods?
Well, the 5 years of OCI status demonstrates a maintained, formalized connection to India, even while holding a foreign nationality. But, and this is key, OCI status is not citizenship.
Right. It's a lifelong visa with certain rights.
Exactly. The subsequent 12 months of physical ordinary residency immediately prior to the application is the state's way of ensuring that the applicant has physically reintegrated into India, that they've demonstrated a serious intention to make India their permanent legal base, fulfilling a kind of modern-day domicile requirement before they're granted full citizenship status.
It's Parliament using its sovereign power to manage the continuing reality of Indian identity.
Precisely.
Now, moving from acquisition to loss, let's look at the foundational constitutional principle that dictates the termination of citizenship. India fundamentally operates on the principle of single citizenship at the national level.
And this is a constitutional mandate, not a simple statutory rule. The relevant text is in Article 9, and it's crystal clear. No person shall be a citizen of India or be deemed to be a citizen of India if they have voluntarily acquired the citizenship of any foreign state.
So that's an automatic and immediate nullification? It doesn't require an order from the government or a judicial review or anything?
Nothing. It's automatic. The moment an Indian citizen voluntarily chooses to take up another state's citizenship, their Indian status is automatically and constitutionally nullified. This constitutional mandate really underscores the idea that loyalty to the state must be singular and undivided. It reflects the deeply held view of the Founding Fathers that in a diverse nation like India, a singular national citizenship was essential for fostering unity and indivisibility.
To stop state-level loyalties from overriding national commitment.
Exactly. It's a crucial distinction from federal systems like the United States, which do allow dual citizenship.
This brings us to the value proposition, the so what. Why does the 6-month residency rule, the July 19th, 1948 cutoff, and the principle of domicile matter so deeply to you, the future administrator? Well, because the status of citizen is the constitutional key that unlocks the full spectrum of guaranteed rights.
Correct. When you analyze the fundamental rights, you see a clear bifurcation. Certain rights are available to all persons, citizens and foreigners alike, like Article 21, the right to life.
Universal human rights.
Yes. But the Constitution grants a specific, high-value set of fundamental rights exclusively to citizens, withholding them from foreigners. So understanding the rules we've just discussed, Articles 5 to 8, is crucial because your citizen status is the prerequisite for claiming these exclusive constitutional protections.
Let's detail these 5 critical articles of fundamental rights that are available only to citizens, as this is prime material for both prelims and mains. We need to understand not just which rights, but why they are reserved.
It's a very important exercise.
Okay, first up, Article 15. This guarantees the prohibition of discrimination on grounds only of religion, race, caste, sex, or place of birth. A non-citizen doesn't have this blanket protection against state discrimination in India. Why is that?
Well, because the state reserves the right to discriminate based on nationality. For instance, prohibiting foreigners from purchasing agricultural land is a form of discrimination, but it's constitutionally permissible because Article 15 doesn't apply to them.
Okay, second, Article 16. This is arguably the most critical for public life. It guarantees equality of opportunity in matters of public employment.
A huge one. The right to apply for and be considered equally for jobs under the state is reserved entirely for citizens. This reservation is absolute because the state believes that public administration and governance positions require singular loyalty and commitment to the Indian sovereign, which only a citizen can guarantee.
Third, Article 19. This is the bedrock of our civil liberties, protecting the 6 fundamental rights regarding freedom. Freedom of speech and expression, assembly, association, movement, residence, and profession. Now, these core liberties are exclusive to Indian citizens. Why are foreigners excluded from these freedoms?
Because granting unrestricted freedoms of expression or assembly under Article 19 to foreigners could potentially compromise national security or public order, especially during times of diplomatic tension.
I see.
The state must reserve the right to restrict a foreigner's movement or residence, even within India, without violating their fundamental rights. It cannot do that to a citizen who enjoys the full protection of these civil liberties against state action.
And fourth and fifth, we have Article 29 and Article 30. These are the crucial cultural and educational rights. Article 29 is for the protection of language, script, and culture of minorities.
And Article 30 grants the right of minorities to establish and administer educational institutions.
Why are these reserved?
These are reserved rights because they are aimed at preserving and fostering the cultural identity of the Indian populace. These rights safeguard internal diversity and minority identity within the Union. Since a foreigner's identity and culture are ultimately tied to their home state, these specific protections are designed exclusively for the constituent population of the Indian Republic.
So, if we look at the contrast, a foreigner is guaranteed protection of life and personal liberty under Article 21 and protection against forced labor in Article 23, because those are seen as universal human rights. But they are denied the right to apply for a government job under Article 16 or the full freedom of movement under Article 19. Understanding the rules laid down in Articles 5 to 8 is the essential historical and legal prerequisite to understanding these citizen-exclusive rights, because citizenship status literally determines whether you possess the full force of the Constitution's protections. Okay, let's unpack all of this and lock in the crucial takeaways from this deep dive into foundational identity. We've established that the Indian Constitution in Part 2 provided a definitive one-time framework for citizenship only at its commencement on January 26, 1950.
It's a snapshot.
Yes, a snapshot. It efficiently dealt with 4 distinct population groups at that momentous time, demanding the critical anchor of domicile for settled residents under Article 5.
And utilizing the July 19, 1948 permit cutoff for incoming migrants under Article 6.
And showing that humanitarian flexibility for return migrants using the 6-month residency test under Article 7.
And we also established that profound constitutional foundation of single citizenship at the national level, which is starkly confirmed by the principle that voluntary acquisition of foreign citizenship automatically nullifies Indian status. It's a demand for singular loyalty.
Right.
And crucially, the power to regulate all subsequent matters, acquisition, termination, post-1950 rules, was placed squarely and explicitly with Parliament under Article 11. And that power is realized today through the Citizenship Act of 1955, which, for instance, requires 5 years of OCI registration and 12 months of continuous residency before applying for naturalization. All of these rules are vital because they determine who gets access to exclusive constitutional privileges like Articles 15, 16, and 19. And here's where it gets really interesting for you, the future administrator, something to mull over for your man's papers. The foundational text in Article 1 describes India not as a mere federation of states born out of an agreement, but as a union of states. This implies 2 non-negotiable characteristics: that the Indian structure is indestructible and that no state has the right to secede from the federation. Okay, now rigorously connect this foundational principle of indivisibility with the fact that the Constitution established a single citizenship for this entire union at the outset.
Right.
If citizenship is entirely national and not state-based, what enduring impact does this constitutional commitment to indivisibility and single identity have on contemporary issues? Think specifically about how national identity clashes with local politics, interstate migration, mobility rights for citizens across state boundaries, and whether any state can legally restrict fundamental rights or access to resources based solely on state residency. The singularity of Indian citizenship powerfully reinforces the Union's supreme authority, constantly challenging regional attempts to create internal barriers for legitimate citizens. It's a concept worth rigorous analysis in preparation for your mains.
That is a critical connection, reminding us that every chapter in the Constitution is so deeply intertwined with that theme of national unity. Thank you for diving deep with us today. Your dedication to learning really does fuel our mission. If you found value in this meticulous analysis, please show your support by subscribing to Simplified UPSC by PPP, liking this video, and dropping a valuable comment below. Remember, your paid membership is what makes this detailed content possible. And don't forget, free notes and practice PYQs are waiting for you on our Telegram channel, and our premium members, our Legend YouTube members, get access to extra PYQs and model mains answers exclusively on Discord. Keep learning and keep succeeding.